Okay, we're going to go ahead and get started. I might have to let some more participants in as we get going here, but I just want to thank you all for joining us this evening. This is kind of that one issue I think that all community associations have to handle, which is the collection of assessments. So my name is Chantelle Neumann. I am the lead attorney of our firm's collections department. I am located here in our Farmington office, and my information is on the screen if you want to take it down at all. Joining me today is attorney Matthew Markley. Matthew is an associate in our firm's collections department, and he is also located in our Farmington office. So some of you may have attended our last presentation on collections, which was actually back in February of 2021. It was kind of during the height of the pandemic, and there was a lot of situations going on, financial situations that people were in. There was a lot of federal regulations as to what you could and could not do at the time. But we're kind of back in the sort of back to normal, I guess, if you will. And all of the remedies that are available to associations are now open again. So we aren't going to focus so much on, on the pandemic, but more just straightforward what it is that associations are able to do to collect delinquent assessments. So I'm sorry, I forgot to give Matthew's slide. There's Matthew's face, so you can see him as well. He will be talking today too. So the topics we are going to cover are the role of the board of directors, the role of property managers, different types of delinquencies, collections policies, timeliness or the timelines for collections, the various legal actions that we can take, lien priorities, lawsuits versus foreclosures, enforcement, bankruptcy, and best practices. So we will have a question and answer portion at the end. Feel free to put your questions in the chat throughout in case you're worried about forgetting them, or just write them down and you can ask them at the end. We would be happy to go over those with you. So we'll go ahead and get started with the role of the board. So as you guys may be aware, the role of the board is really important in keeping up with assessments and ensuring that payments are timely received. The board has to keep accurate records. And so this includes, and this may shift a little bit depending on whether your association utilizes a property management company. But it's really important to have the names of the owners of all of the units or lots, whether if your association allows rentals, the names of the renters and the tenants in the units, including copies of the leases, which we will talk more about why that's important later. Off-site mailing addresses. So if an owner does not live at the subject property and they're only there during periodic times and they want notices to go to other places, it's really important to have a list and a process for keeping those off-site mailing addresses. Another thing is email addresses and phone numbers. Whether it's in cases of emergency for phone numbers to be able to reach owners, or just, today a lot of people prefer email. I've heard of people not checking their snail mail for days now. And so sometimes it's just easier to get to someone via email. And then also records of payment. So it's very important to keep some kind of accounting showing all of the charges on a unit, all of the charges on a lot, and then detailed payment information, which shows how it was paid, when it was paid, where it was received, any check numbers or other instrument numbers as well. In addition, the board works with the partners that the board decides to contract with. And so whether that's property managers, if your association retains a property management company, or with law firms like ours, it's it's important for the board to have that communication in that relationship. So another important part of the board is to make sure to not ignore delinquencies as they come up. To make sure that you're staying informed about the status of accounts, so that way when you know, things don't get too far behind without you knowing, and then it becomes a more difficult situation. Also, for the board to be flexible, the board does have an obligation as a fiduciary duty to the association to collect the amounts due. But oftentimes, if you're too rigid about working with individuals to try and resolve their balances, that can sometimes have a negative effect on the association as well. And then also to treat everyone the same. So every case is different, you know, everyone has different circumstances, but everyone has to be treated the same to avoid any accusations of discrimination or other issues that could come up if the policies are not handled across the board in the same way. And then lastly, communication. It's always important to put everything in writing, via email if you're going to do that, to be professional in those emails, and then to avoid confrontation. You know, it just makes things more difficult to get things resolved, especially these balances, if people are taking things personally and put their personal issues into it. So try to avoid that as much as possible. Next is the role of the property manager. So the role of the property manager is largely laid out in the management agreement that they sign with the association. It'll lay out what exactly it is that they're in charge of, what their what costs are, all of that, and what the expectations are. So that way the board and the property manager each know kind of what falls in their bucket and what they're responsible for. The property manager also is meant to keep the board informed. So if the property manager is the one who's primarily working on delinquencies, they need to, you know, attend meetings and keep the board apprised of the status of the accounts in the community, as well as providing status reports, whether that's provided by an attorney or the property manager. It's really important to provide those at least on a monthly basis so everyone can stay up to speed on what is happening with assessments or delinquencies within the community. And then also the property manager serves as a liaison to both the community and to the board, and then also to the attorneys. So if your association utilizes attorneys to handle your collections, typically the property manager will be the one to communicate, you know, conversations they've had with the owners or special circumstances with the owners, and then communicate that. So all of the individuals involved in the collection process are fully informed. The property managers also send the delinquency notices. So they are usually the first line of communication to the homeowner, advising them of the delinquency. Before it even gets to our firm or another collection agent, there should be a delinquency letter, which we will get into more detail about. And then also relaying payment plan proposals. You know, if a homeowner is just on difficult times and not able to pay, but they're asking for some kind of workout to be able to resolve their balance, the property managers will often be that communicator of what those proposals are and working on trying to resolve it in some amicable way with the owner. So why do community association members become delinquent? So one reason is just falling on hard times. If they've lost their job, if they have unexpected medical bills or other, you know, financial difficulties, they really are struggling to pay. Another reason is if the unit or the lot is a rental and the owner has different people living in the property and they haven't provided that notice to the association or an offsite mailing address to say, I'm not at the property, I need you to send notices here. Notice is going to the subject property, but their renters aren't sending it to them, so they're not aware that there's an issue. Another reason is, which we've seen a lot of recently, is if there's a new management company and individuals don't realize if they're on auto pay that they have to set up a new auto pay with the new management company. And it's surprising, but a lot of people don't check their auto pay to make sure that it's still coming out. So they think they're good. They don't pay attention to the mail saying, hey, there's a new management company, you have to set up your new ACH, and they just get behind. And so then when they get a notice from our office, they say, they had no idea. Another reason is abandoned properties, whether it's from a homeowner passing away or some other reason, if the individual just couldn't pay their mortgage anymore, or they just had to move and they just had to let the house go. That may be another reason. And then lastly is repeat offenders. So these typically are just either people that are careless and are not diligent about paying their bills, or else they intentionally do it. I've heard of people saying they don't care about late charges. They're only going to pay their assessments 3 months at a time. And instead of paying ahead, they pay behind. And it's just how some people handle their assessments, unfortunately. And then another thing is just angry members. So these are the individuals that intentionally or purposefully withhold assessments for one reason or another. It could be because they have bylaw violations and they disagree and they don't want to pay the amounts that the association is assessing to their unit or their lot, and they're just not going to pay. The other reason is a large special or additional assessment. If either they just can't pay the full amount, or they didn't approve of it, they don't think it should have passed. We see that a lot with homeowners saying, well, they're just not going to pay it because they don't agree with it. And then another thing is maintenance disputes, whether it is, the association telling a homeowner that an issue was within their unit, they need to pay the maintenance costs, and then usually it's the homeowner saying, well, no, this is a common element, this is your requirement, you're required to pay it, your insurance has to cover it, or there's just disputes with insurance as well. And so the question sometimes comes up is, can a homeowner escrow their assessments or withhold their assessments if they're upset about something, or if they're asserting the management company or the association didn't do something that they were supposed to do? But pursuant to MCL 559239, that is not a defense to non-payment. The homeowner, their recourse is to file a lawsuit against the association if they think there's something the association didn't do that they should have done. So that would not be a defense. They should continue paying their assessments. So we're going to move on next to collections policies, which Matthew is going to cover. So I'm going to hand this off over to him.
Great. Thanks, Chantelle. And I'll just introduce myself again. Matthew Markley. I'm an associate attorney in the collections department at Hirzel Law. So I'm going to pick up the presentation for a few slides here. First, I'm going to speak on collection policies. So essentially, what is a collection policy and why have one? A collection policy is simply a document that is passed by the board that outlines how the collections are going to work for anybody that has delinquent assessments. You'll ask, why have this if we already have governing documents or bylaws or anything like that that already state, what can happen if people are delinquent with assessments? Well, I think importantly, first, it puts everything forward so everybody can see clearly exactly the intentions of the association when it comes to delinquent assessments. You can start from A to Z, and everybody's on the same page with how things are going to work. And I think that's important because that ties into what Chantelle had said earlier with regard to treating all co-owners equal. That's a very important thing that needs to be done, because if you treat co-owners differently in certain situations, it can lead to issues of discrimination or claims of discrimination or selective enforcement to certain people rather than others. And so a collection policy is good to have because it clearly tells everybody this is how we're going to treat this issue. Once again, Chantelle noted as well that the board has a fiduciary duty for collecting assessments, and this just goes to help streamline that process. Like I said, you put timelines in the collection policy to explicitly state how long somebody's going to have before it gets turned over to a collections attorney and start that process. You can note payment plans and specifics for how the association will consider a payment arrangement, if any at all. For instance, maybe if the value is below a certain threshold, there will be no payment plan, or if it's above, there's a certain time limit on how long the delinquent co-owner can have to basically pay off whatever outstanding assessments may be on the account. Lastly, the collection policy will spell out the legal procedures if it gets to that stage. So if it's gotten to the point where the collections policy, notices have been sent and everything like that, there's no response, then it will get turned over, to an office like ours for handling, and there we can lay out exactly what we'll do, whether it's an initial demand, a lien, foreclosure, etc., depending on the situation and how far it goes. The most important thing about a collection policy is that it can't conflict with the association's current governing documents. So it basically is just going to parse out the important details from the documents that already exist to a degree, and it can't write something in that isn't allowed or isn't written in existing documents. You can do that, but you would have to amend your documents accordingly so they match. Lastly, attorney review. Obviously, if you have a collections policy or you need one drafted, obviously the attorney will review that and provide legal updates as necessary and adjustments to make sure the policy is in line with, once again, the association's governing documents, to ensure everything is streamlined and there is no issues or challenges down the road when the association does decide to pursue a collection against a delinquent co-owner. Okay, so a member is delinquent, and what happens next? So this can tie into a collection policy as well, but if you don't have one, this is just a general framework of how you might go about next steps with a delinquent co-owner. I do want to emphasize that the dates on our PowerPoint here are just a framework. If you already have a collections policy or specific rules or regulations for your association regarding how many days or the timeline for collections, you'll want to refer to that. But for purposes of our slide here, we're going to follow this framework. So a member is delinquent, 15 days delinquent, a letter should be sent by the board or property manager letting them know the delinquency. And then importantly, if it's a self-managed association, the letter should be signed by the board of directors or association. So you'll send the first notice, and then if 45 days go by after that and there's still no response, you'll want to do a follow-up delinquency or a second delinquency letter. At that point too, you might want to take a look and see if there's an email or an alternative address. I know a lot of times, especially with condominiums, the co-owner doesn't actually live at the unit address, but they may have a secondary address that they do reside at if they're using it as a rental. So you want to make sure that you try to reach out in different ways if you can. importantly, to try to resolve it before it gets to a stage where you have to turn it over to an attorney. So if 60 days go by in whole and there's still no response based on your second letter, and you've done your due diligence, then you should turn it over to an association attorney, and we'll start the process by sending a demand letter, and go through our normal procedures for collection. The most important thing is once it is turned over to an association's attorney, you want to make sure that you avoid personal contact with the delinquent members. This is important for a variety of reasons, but most importantly, it is important that once an account is with the attorney's office, that all the communication goes through the attorney's office, to avoid conversations that may happen outside of that the attorney isn't aware of, and confusing the situation or making it more drawn out than it needs to be, or agreements that may have happened without the attorney knowing about, and then they find out later and it just kind of convolutes the situation. So I want to make sure that once it does go to the attorney's office, that the attorney is the primary contact for communication with the co-owner. That doesn't mean that if the co-owner calls you, you have to completely ignore them, but you can simply say, this account has been turned over to the attorney's office. Please contact him. That's it. No further discussion, just to try to keep everything. One line of communication is best for these types of situations. Here is just a little comedic relief. So some bad ideas related to delinquent members and collections. So what you want to avoid due to privacy law and debt collection law is you want to refrain from publishing a list of delinquencies or sending out an email blast to the community that says, these people haven't paid their assessments and they're behind, et cetera. You want to refrain from basically calling out the delinquent co-owners. Additionally, you want to refrain from confronting the delinquent members, whether that, there's no need to do that, especially once it's been turned over to the attorney's office, because they're the one that will be doing the demand and sending it to them, and then controlling the communication as the intermediary between the association / property management company and then the delinquent co-owner. Okay, so I kind of touched on this before, but more specifically, when should you get legal involved? So for following that framework from a few slides ago, we had our framework as 15 days, 45 days, and then 60 days without a response or payment. So we've reached the 60-day point, and we had the 2 prior letters sent by the board of the property management company, and now what? So after that time, if you're dealing with a condominium, if you have regular monthly assessments, we recommend that after that 60 days or longer that you send it to the attorney for legal action and handling. If you're a subdivision or an HOA, it can vary a little bit depending on the way the assessments are set up. So if you have a relatively low annual assessment, we recommend that maybe you wait for about 2 years time for that balance to accrue a little bit of outstanding before we turn it over. If it's a few $100s though or more, we recommend that you would turn it over to our office, and we may go ahead and just file a lien immediately rather than starting with the initial demand in an effort to try to place a lien on the property, so that way the outstanding balance is at least recorded in to some degree for collection purposes. Okay, statute of limitations. So for condominiums, it's a 10-year statute of limitations. There's not much to point out there other than the fact that that is a relatively long statute of limitations. Normally it's just a few years, so 10 years is fairly notable. With regard to subdivisions, it's a 6-year statute of limitation, and that's based on the breach of contract statute of limitation in Michigan. It could go up to 10 years. That will depend on the recording of the relevant documents. And so that could be adjusted here or there, but typically condo 10 years, subdivision 6 years. Okay, legal procedures. So you've gotten past the 60-day point, you've turned it over to the attorney's office. What exactly, are we going to do? So typically, if we're just focused on a demand letter at first, which is the typical trend, once again, it varies depending on the situation and the amount outstanding, or a variety of other factors. But assuming we're starting with a regular procedure, our office will conduct a title search. What we want to do is confirm ownership, get a copy of the deed, and determine if there's any mortgages or tax liens, and kind of figure out where the association, whether it be a homeowners association or a condominium association, falls within that priority per se. We'll also conduct a bankruptcy search. That's important. We need to be able to figure out that if somebody is in bankruptcy, how we go about dealing with that. If there was a prior bankruptcy, what assessments can or cannot be collected, and that will vary depending on somebody's bankruptcy situation. So we'll perform a bankruptcy search and verify that. We'll do a tax record search. That's important for locating alternative addresses for the person, the co-owner, or also determining if there's any renters. So that is actually a very important step. Like I said before, a lot of the owners or co-owners don't always live at the unit address. It's being used for a different reason. So we can verify that and make sure that our demand letters get sent, hopefully where the owner will find it. Then we'll review the ledger provided by either the association or the property management company and verify the account charges and ensure that that is accurate and up to date. And then after that, we will prepare a first demand letter to the owner or the co-owner, giving them 35 days. It's 30 days plus 5 business days for them to tender payment in full. And that would be the basic first step legal procedure for handling a delinquent assessment.
Helps to unmute. So like Matthew stated, we do review the balance before we send out the initial demand letter because it's our job. We have requirements under the Fair Debt Collection Practices Act to verify the amounts that we are demanding from the owner. And so we will look through, and obviously there's different things that will go into calculating the balance. So the statute of limitations, we're going to review to make sure that there's not anything the association's trying to collect that goes outside of that statute of limitations. And then making sure that all amounts were properly levied. So if there's a special or additional assessment, reviewing the association's documents to see what was required to pass that assessment and getting documentation to verify that was done correctly. And then late fees. So late fees, I know Matthew touched on those. They must be reasonable. Sometimes they're viewed through the lens of the amount of the assessment, which does come into play. If you have a $100 assessment or monthly installment of your annual assessment, and then you have a $100 late fee, a judge is not going to consider that to be reasonable. But what they look at is it's supposed to be a reasonable estimate of the administrative costs and other damages that are incurred by the association in connection with the late payment. So you want to be able to justify that late charge with okay, well, what work has to be done because of the late payment? What goes into having to correct the delinquency because of that late payment? Those can all be factored in determining what's a reasonable late charge. Also, we look to see if interest can be included. So if your bylaws allow for interest, the maximum legal rate under Michigan law is 7%. If your bylaws state an amount that is above 7% and it doesn't have any other indication that the board's allowed to adopt a different amount, then we would not be able to include interest, because that would be a usurious interest rate and we would not be able to use it. Your documents would have to be amended to have an interest rate of 7% or below for us to be able to collect that. Another thing we look at is fines, whether those were properly levied, which I'll get into that a little more as well. And then collection costs. So if you have a management company and there's certain fees that are attached to certain tax that they do, and those get billed to the homeowner, those have to be justified in compliance with the management agreement between the property manager and the association. So here is to get into more about the considerations with fines. Subdivisions don't typically have the right to fine unless some do put it into their documents. So if it's in their documents, you just follow whatever is provided for in the documents. As far as condominiums, MCL 559206 is what applies in fine situations. It says that the association can levy fines against co-owners after notice and hearing thereon. So the association, this comes up with situations like an owner continuously leaves their trash can out and doesn't put it away in a timely manner. The association's not going to want to sue that co-owner for that issue, but it's becoming a complaint in the community. And so you may say, okay, let's try fining this individual to see if we can get them to correct their behavior. So to do that, you would have to send notice to the individual with a scheduled hearing date and give them an opportunity to appear at that hearing. You cannot just send them the notice and say, oh, you can request a hearing. You actually have to hold that hearing. So if they don't show up, they're in default and you can start fining them after that with additional notice. If they show up, you can still fine them liable for the bylaw violation and start fining them. But you just need to be sure that that meeting is actually held. Otherwise, if we see fines on a ledger and we ask if that meeting was held and it was not, if there's no meeting minutes to show that, then we may not be able to include fines in the balance that is due. As far as late fees, I did reference the reasonableness of those. Typically, late fees aren't something that an association is going to budget for. And so those can be used typically as a bargaining chip in trying to resolve a balance with a homeowner. Sometimes they just want to feel like they got something, they got some reduction. The same thing with interest as well, if interest is allowed under your documents. So we recommend, in trying to get settlements in place, trying to get payment plans in place to waive late fees in exchange for timely payments under a payment plan. Typically, it's not just a full-on waiver. If you're entering in a payment plan, you want to see, okay, if you comply with this payment arrangement, we'll then waive late charges. And then with settlements, though, it may be if they're able to make a lump sum payment, but they need a waiver of some of the late charges to be able to do that, we typically recommend that. And that kind of goes back into what we were talking about with the flexibility at the beginning. So payment plans, these, like we said, just you need to be reasonable, because sometimes people are just in a very difficult situation and they may be considering bankruptcy. And then if you go into bankruptcy, it's going to increase fees. And if they go into Chapter 7, they could get the debt wiped out altogether. So it's better to get what you can when you can. Also, it minimizes legal fees. You know, if you're working out payment arrangements before having to refer it to our office, it avoids our office incurring fees for the association and making it then harder on that homeowner to pay, because now they have additional amounts when they're already struggling. Obviously, though, that depends on the circumstances with the homeowner. It may be a situation in which there's other things going on, whether it's an angry member situation or not, but these more are for those homeowners that are really trying but are in a difficult situation. And then make sure you document any agreements that are reached. If you have an attorney, we recommend that your attorney prepare it, that the homeowner signs it, and it can be done via email. They can do signatures via email, but to make sure there's some kind of documentation regarding it. Also, it may be helpful if you're an association, a board that uses a property manager, to give your property manager a certain authority up to a certain amount to enter into these agreements. If you do that, it kind of expedites the process and makes things easier to reach resolutions on some of the accounts. And then the question always inevitably comes, what if they default? So the agreement usually will typically state what will happen if they default, but it's that the association can proceed with their remedies, that they can proceed with collection, whatever that next stage is, whether it's recording a lien or foreclosure, or referring it to an attorney to start the collection process. And on that note, the next thing is when we handle a lien. So recording a lien is the putting others on notice of the association's interest in the delinquency that has happened. We send a notice of lien letter. So we'll prepare the lien and we send the notice of lien letter to the homeowner all together. We send it certified mail and give them 14 days to pay in full. And we also mention the foreclosure remedy, depending on what remedies are allowed in the association's documents. Recording the lien is similar to a mortgage. It protects the association's lien position, and I'll get into more about lien position as well. But it also, I see we have a question that might address this a little bit, but if there's a lien on title, the property should not be sold or refinanced without that lien being paid off. If the closing is done correctly, the lien should get paid off at that closing. Status letter should be requested from the association, and the association can provide the balance of the debt that's owed on that lot or on that unit. And it says payoff requests from banks. They typically come from title companies or title agents. Some of you may have dealt with do condo certifications or condo questionnaires as well. So in Michigan, the recording statute is first in time, first in right. So in general, if your document is recorded first, it's generally treated first. It's in the order of interest. It means we use the terminology superior or prior. So if it has first priority, that means it's first in line. If it's second priority, second in line. And MCL 56529 generally handles the race notice statute. But there are different kinds of liens that are treated differently in Michigan. So property tax liens have absolute priority. If there's a property tax lien, it goes over all other interests that are on the property. And that's outlined in the statutes that are cited. If a property tax lien gets foreclosed, it foreclosed out all other interests that are on the property. For state tax liens and federal tax liens, those only get priority over everything they're recorded before. So it's first in time for those. With construction liens, those have to be recorded 90 days after the last date on which labor or materials were furnished. And a construction lien has priority over all other interests that are recorded after the first actual physical improvement to the property. But they only have 1 year from the date of recording of that lien to foreclose on it. And then with condominium liens, it's again first in time. So if a condominium lien is recorded before a mortgage, it takes priority over that, over a first mortgage. But as far as second mortgages, pursuant to MCL 559208, which is the Michigan Condominium Act, the association's lien will take priority over a second mortgage. So we'll get into that in a little more detail. There is a conflict in law between construction liens and condo liens, where it's not very clear, like there's a disagreement on both sides as to which is handled with priority. So it remains to be seen how those would be handled. So because a condo lien takes priority over a second mortgage, it's sometimes beneficial to send a letter to the second mortgage holder threatening, or not threatening, but telling them that the association is considering foreclosure. By doing that, the second mortgage may want to preserve their lien interest. So they may choose to pay off the assessments and then add them to the balance on the mortgage. That is an option. We do see them sometimes taking that action. So there is case law on the priority of federal tax liens versus condominium association liens. Federal tax liens, in this case, it's Yarmouth Commons. They had claimed that a federal tax lien took priority over the condo lien. But the condo lien, which was recorded first before the IRS's tax lien, was treated with priority. So another option that we don't really see too much, but it is out there, so I'll briefly mention it, are deeds in lieu of foreclosure. This is where a homeowner, they don't want to get foreclosed on, but they don't want the property anymore. So they will just transfer title over to the creditor, whether it's the mortgage holder or the association. It's a way for them to just be able to walk away and avoid having a deficiency judgment against them. It is beneficial for creditors to not have to incur the cost of foreclosure and go through that process and wait out a redemption period. But the risk is for associations is that if there's liens on the property, those liens will remain. So the association, if the homeowner's underwater, there's not enough value in the property, it most times doesn't make sense to accept the deed in lieu. And you'll see here on the screen that there's case law that held that when an association took a deed in lieu, they lost their priority over a second mortgage. So if they would have foreclosed, the second mortgage would have been extinguished. But if with taking the deed in lieu, now they still have two mortgages on the property that they have to try and pay off when they sell the property. So it really, a lot of times it just doesn't make sense. So I'm going to get into talking about the different remedies of filing a lawsuit or proceeding with foreclosure. So the pros, well, there's two types of lawsuits that you can file. You can file one for just money judgment, or you can file one for money judgment and foreclosure. We only recommend filing one for money judgment when the homeowner is known to be collectible. That means like you know they're employed, that they have wages to garnish, they have assets that can be seized. But it's also a good option when the association is just not interested in having title to the property. So obtaining a judgment or a judgment in a lawsuit, you can have that judgment that lasts for 10 years. Like I said, you can garnish wages, you can seize assets, and this is an option when there's no equity in the property, and foreclosing would not be a viable option. The cons with this though, that it is a time-consuming process. It can take 4 to 8 months in general. It is much more expensive, the attorney's fees and the expenses of litigation. You have to locate all of the owners and serve them. And then it also gives the owners an opportunity to contest the action and, bring up defenses to the assessments, which then increases the fees even more. And then also it puts in the hands of a judge to approve all of your legal fees, your late fees, to determine if they're reasonable or not. And even though an association may be entitled to their actual attorney's fees under governing documents, it does not mean the judge has to award them. The judges often will reduce the fees that are incurred on a file. So you do run that risk of, incurring legal fees that the judge may ultimately not require the homeowner to pay. So with foreclosure by advertisement, which is the option we typically recommend if a file gets to this point, if your governing documents allow for it. I know a lot of subdivisions don't have these provisions in their declarations, but some do, and they allow for foreclosure by advertisement, which is the process. Just a brief overview. You prepare a foreclosure notice. If your documents require you to serve it on the homeowner, then you send notice to the homeowner with the foreclosure notice. It's published for 4 consecutive weeks in a local newspaper. And then the sale is held in the county, usually at the circuit court in the county where the property is located, and it's auctioned off by the sheriff. The association has the option to either do a credit bid, which is the amount that's due on the lien. So let's say the lien has $10,000 outstanding. The association would just submit a $10,000 bid. There's no exchange of funds. You're just telling the sheriff, hey, there's $10,000 owed on this. We want you to open the bidding at that amount. If the association wants to bid higher than that, someone actually has to attend the sale on behalf of the association and have funds on hand for the difference between the credit bid or the lien amount and the amount the association wants to bid. So if that lien is $10,000, but the association says, well, we want to try and get this property, we think we can fix it up and sell it for a profit and put it in our reserves, so we want to bid up to $30,000. Someone would have to attend the sale with that extra $20,000 to be able to pay the sheriff if the association is the prevailing bidder. So what we've seen in recent months is because of the speed of the process and obviously the seriousness of the process, a lot of accounts get resolved at this stage. A lot of individuals that, whether they were in denial or just ignoring what was going on, a lot of them will pay once we get to that stage. The cons with it are that if no one outbids the association and the association doesn't really want the property, then the association will now have to, market the property for sale, wait out the redemption period, which is also on here. And then the debt is gone at that point. So the only way for the association to recoup the loss is to wait out the redemption period and then sell the property and hopefully pay off any liens that are on the property. There is, although there's a 6-month redemption period, there are 2 options to shorten it. The association can do an abandonment process if there's no one there, if it's one of those situations where the owner may have passed away and no one's taken responsibility for the property. You can complete the abandonment process, which will shorten it down to 30 days. Or there's a statutory inspection process where the association could send notice to the occupants and require them to allow an inspection of the property. The statute only gives so many inspection rights during the redemption period. But if there is emergency circumstances, if there's fear of waste at the property, if the association finds there is damage being done at the property, and obviously the association wants to preserve that interest, then you can file for an eviction action if they refuse to make the repairs or if they refuse to allow the inspection. And the eviction action would be filed asking for the redemption period to be shortened. So I'm going to go through just a couple of examples with everyone. If you want to just throw in the chat, I'm going to give you some examples of when it might be a good idea to foreclose or not a good idea. And so if you could just throw into the chat whether you think each of these examples are a yes, you should foreclose, or yes, you should file a lawsuit. So just put foreclose by advertisement or lawsuit. So example 1, the association is owed $5,000. The property is worth $100,000 and there's no mortgage on the property and there are no unpaid taxes on the property. And so we're assuming that there's no other lien interest on the property either. Would you say the association should foreclose or should file a lawsuit here? And you can just put those in the chat. So that's correct, foreclose by advertisement. So here, the property is worth $100,000. There's no other lien interest. The association is only owed $5,000. There's a potential for a $95,000 profit there. This is one the association would maybe even want to consider, assuming you had money in your reserves, to overbid on this, to try and get the property to fix it up and sell it and make a profit for the association's reserve fund. So with example 2, the association is owed $5,000. The property is worth $100,000. There is a first mortgage for $90,000 and unpaid taxes for $15,000. Should the association file a lawsuit or foreclose? Yep, you guys are right. This property is clearly underwater. It has $105,000 without the association's lien, and the association could end up with a severe loss by just foreclosing on this one. So example 3, the association's owed $5,000. Property is worth $100,000. There is a first mortgage of $80,000 and then a second mortgage of $30,000, but there's no unpaid property taxes. So with this one, we would actually recommend foreclosure because I didn't state this, but you're assuming that, well, actually it doesn't matter. The second mortgage would get wiped out. So you don't consider the $30,000 for the second mortgage. So with the property worth $100,000 and the first mortgage $80,000, there's still, and then if you add in the association's 5,000, there's still the potential for $15,000 of equity there to be able to pay off the first mortgage and the association's lien. And then with all of these, you would place a lien first. You would have to be able to foreclose. You would have to have the lien in place first. So I'm just going to go through some other additional enforcement actions, or I guess parts of the enforcement process when an owner is delinquent. So acceleration clauses. Sometimes the association's documents will have acceleration clauses, which state that when a homeowner is in default, the remaining assessments for the fiscal year can be declared immediately due and payable. So this provision doesn't necessarily help you so much in December or November, but if it's the beginning of the year, if you have early delinquencies, you could require for them to cure their delinquency, them to pay their entire assessment for the full year, their entire annual assessment, all installments of it. We don't usually recommend this at the demand stage because we're just trying to get the balance current and get the delinquency resolved, and accelerating the balance at that stage is likely going to make it really difficult on the homeowner. But, you know, at the lien stage, and especially at the foreclosure stage, we do recommend exercising this option. Another option is rent diversion. So if the unit that's in default has tenants in the unit, you can send a letter to the tenant telling them to pay their rent directly to the association. And that statute is MCL 5592125. I'm just going to read a little bit of it. It says, when a co-owner is in arrearage to the association of co-owners for assessments, the association of co-owners may give written notice of the arrearage to the tenant who's occupying the unit under a lease or a rental agreement. If the tenant, after receiving the notice, they have to deduct from rental payments due the arrearage and future assessments as they fall due and pay them directly to the association. This does not constitute a breach of their rental agreement. And if they refuse, the association can evict them from the unit. In addition, members that are delinquent, if your documents say they may be ineligible to vote, but they are still entitled to attend the meetings, you cannot tell them they're not allowed to be present at the meetings, but they do not have a vote in any association business that happens at that meeting. Also, they're typically not eligible to serve on the board of directors if they have a delinquent account. So another option is if owner is in default, they may not be permitted, assuming the documents reference this, they may not be permitted to use certain recreational facilities or common areas that you have in your community. So let's say you have a community pool. Their access to that pool can be turned off if they are in default, if your documents allow for it. But the really important thing here is to make sure that you're not depriving them of ingress or egress to their unit or their lot. They still must be able to access that. It's just if they, it's just the common areas and the recreational facilities that they should not be allowed to access. Another consideration here is if an account is in bankruptcy, you do not want to violate the automatic stay, which is the once an individual files for bankruptcy, the bankruptcy court says you have to stay all of your collection against them. The bankruptcy courts could deem it a violation of that automatic stay if you do deprive an owner of the common areas as well as utilities, which is the next thing on the slide. Some documents allow for the shutting off of utilities after 7 days notice, but in the bankruptcy arena, you want to be really careful with that. And actually, just in general with utilities, we've seen that judges do not like that remedy being exercised. We've seen judges issuing TROs to require associations to turn back on water or other utilities that they may have shut off. But it is a remedy that is allowed if the association feels they're just in a situation where they have to exercise it. There are assistance programs in Michigan that an association can sign up for and partner with if a homeowner in their association is trying to get assistance. So it used to be the Michigan State Housing Development Authority's Step Forward program, but that had recently closed, kind of recently, on June 30th, 2021. But now on February 14th, 2020, the Michigan Homeowner Assistance Fund opened to help individuals who have been impacted by the pandemic. And I included the link there. The association can become a participating partner by completing the collaboration agreement. And then there's a contact and ACH instructions agreement. So the requirements to qualify for assistance under the program are the homeowners have to have household incomes less than 150%. Sorry, my light goes up. Of the area median income. Homeowners who own and occupy the property as their primary residence. So this wouldn't apply in leasing arrangements. And then homeowners have to explain a financial hardship directly related to COVID-19 on or after January 21st of 2020. And they can get up to $25,000 grant per household, which would pay the list of things there, which does include condominium and homeowners association fees, as well as utilities like gas, electric, water, and sewer. So I'll just briefly touch on bankruptcy as well. So there's two types that we commonly see, the Chapter 7 and the Chapter 13. With the Chapter 7, well, with both of them, you have to cease all collection efforts as soon as you find out that bankruptcy is filed. With the Chapter 7, it's a discharge of all of their debts. So they're asking the court to just wipe their slate clean, give them a fresh start. If they do receive that discharge, then the association cannot pursue those debts. They have to just bring them to a zero balance and charge off those amounts. With a Chapter 13, this would be more like a monthly payment plan. The association would file a proof of claim outlining any of the pre-petition, meaning any of the amounts that were incurred prior to the bankruptcy filing date. And then the plan is supposed to account for any amounts prior to that filing date, and then the ongoing assessments. And if the plan doesn't properly account for the association's amounts, then you can object to the plan. One really important part of this is you want to make sure there's some process in place for flagging accounts that are in bankruptcy, because notices have to be filed anytime there's an increase in the assessment amount, at least 21 days prior to that increase happening. So if you have your annual assessment restarts in January and it's going up, you need to make sure if you have an account in bankruptcy that you notify your attorneys that it's going to be going up, so they can file a notice with the court saying, okay, now they need to pay more each month. Same thing with attorney's fees or other costs. If there's costs that you need to assess to the unit because, let's say, there was labor or maintenance or things like that that are incurred, notice needs to be provided to the bankruptcy court that there's new amounts that were being assessed. So it's really important when an account is in bankruptcy that you have good communication with your attorneys and let them know what's going on so they can file any required notices. So ways to streamline the collection process, we're seeing a lot, obviously. A lot of people don't want to deal with checks anymore. They want to do electronic payments. And so we get that a lot. Even our office will take payments electronically because people really do prefer that avenue. So if you can set up ACH and get auto payments coming in, and then also if you don't have ACH, have the credit card, debit card options to take payments electronically. There is the potential for it to be a lot cheaper and a lot more efficient. I think there was a question regarding e-notices and things like that. It cuts down, especially with mailing and postage going up so much. It will cut down on the time and expenses of sending these notices. So we are going to go ahead and get into our Q&A. And I see we have a number of questions already. So we're going to go ahead and get started and try to start answering them. I know we're already over. I think our time was only for 6 to 7 p.m. So if you do have to go, we understand. But the first question, I see, Judy, you may have been communicating on this. But I see that you have an owner, they bought a place and they were not told by the owner or property manager there was an assessment of over 1,000. So was the assessment, the question is, was the assessment in place when the property was sold, or was it an assessment that took place after they became owner? Because if they were the owner at the time of the assessment, it would be their obligation. If the assessment took place prior to their ownership, it's still an interest on the property. It's still a lien on the property, but there may be a situation where they need to, I don't know if there was a title company involved that maybe missed that, because really it should have been a request sent to the association as to the assessment amount. So I would need more information to really be able to help you out there. But it sounds like if they did an actual closing and there was a closing agent, that the new owner might need to go talk to them and find out why it was not covered at the closing. Here's another question. Are email delinquency notices now valid without duplicate snail mail notice? That really depends on your documents. I would recommend a process in place that allows people to elect electronic notice if that's what they prefer. But I think you still have to have, unless your documents state that notice will only be sent electronically, I think you still have to send those snail mail notices. And it really, until you have a process in place to ensure notices are reaching owners electronically, it really is recommended, because it avoids those arguments about not receiving the emailed notice. But if you have that process in place where someone verifies their email address and it's a good email address that they're receiving notices at, that may be an option. So I see a question, Matt, that you may want to handle. It says, please advise when to begin to send letter to late owner. Also, when do we start the lien and foreclosure? What is the recommendation with the co-owner to do a payment plan? And then are all legal fees charged back to the owner?
Okay, yeah, I don't see that question for whatever reason, but It sounded like there was a lot to unpack there, but
Yeah, I will send it to you.
okay. Okay. Okay, so with regard to question one, when to begin to send letter to late owner. So that's going to once again depend on whether or not you already have documents in place for your association that spells out how you handle these types of procedures. So if you have a collection policy or another rule and regulation in place, it may already state, you know, after 30 days, a notice is sent to the delinquent owner or co-owner from the association of the property management company. Our timeline was just a framework where we had said, you know, after 15 days delinquency, send the first notice. After 30 days, send a second notice. 60 days in whole, you know, turn it over to a collections attorney. So that question will kind of depend on if there is a policy in place to a degree from the association already. If not, you know, you could draft a collections policy. If there's nothing in place, then we would recommend that, you know, the board get together and figure out, you know, how they want to procedurally handle these types of issues. So I guess the question doesn't necessarily have an answer. It's going to be dependent on what the association decides it wants to do. I don't know if you have anything to add to that, Chantelle. If you do, chime in. If not, I'm going to go to the next question on the list here.
Nope, go ahead.
So the second question, when do we start the lien and foreclosure? So associations and property they do liens on their own if they wish. Our firm does the liens as well. So if we're following a collection being turned over after 2 or 3 notices sent to the co-owner or the owner, and it's turned over to my office, the typical process is we'll start with the initial demand, and that will come from our office. If that doesn't work, then we'll proceed with the lien upon approval by the board. The lien, like Chantelle said, we'll place the lien, we'll get it recorded, we'll send them notice, and they'll have 14 days to pay. If they don't pay within those 14 days, then we'll come back to the association and say, hey, we still have a delinquent co-owner here. We haven't heard anything from them. Why don't we look into our third and final step, which could be a variety of things. This question mentions foreclosure. That's the time where we'll analyze the mortgages, any other liens on the property, make a determination as to whether foreclosure is a good option or whether a lawsuit or money judgment, as Chantelle went over and those questions went over, is a good option. So really it's kind of a 3-stage process. And that's typically how we handle it. I think one of the earlier slides with subdivisions did mention that if their annual assessments or they're relatively high, we may proceed just straight to a lien. It's also going to be, you know, case specific and depending on what the situation is with the co-owner, if they're trying to quickly sell the unit or the property. So there's different scenarios that will depend on how we may modify our 3-stage process. The third question, what is the recommendation with the co-owner to do a payment plan? So I'm not exactly sure of what the question is getting at, but with regard to payment plans, typically, as Chantelle noted earlier, if the association is interested in agreeing to a payment plan with a co-owner, typically, depending on the terms of the plan, we always would recommend a payment plan. I think, you know, to amicably, resolve a delinquent account and get things. I'm seeing I think this is the adjustment to my question. If do the payment plan, how long recommend. So as far as the timeline for the payment plan, typically we recommend having a payment plan resolve a delinquent balance, in a year's time or less. Once again, that will depend on the outstanding amount of the delinquency and what the co-owner is willing to pay. But typically, if it goes any longer than a year, it's not worth the association's time to involve itself in that, because the new fees that are incurred will just continue to increase, and there'll be a long time before the association ever gets paid back. So with regard to the payment plan length, it's going to be situation specific, and it's going to depend on how much the co-owner is willing to pay each month towards a delinquent balance, as well as the new fees if it's a monthly assessment. So it really will just depend on the situation. Question 4, are all legal fees charged back to the co-owner? So yes. So the governing documents typically state that legal fees, cost, interest, and any other charges are the responsibility of the owner, the co-owner, when they have delinquent assessments and it's turned over, to our office for collections. I do want to reiterate though, and Chantelle touched on this before, the legal fees are charged back to the owner in the collections process. But if you get to the stage where you're filing a lawsuit, that isn't always the case when the judge gets to make the decision on whether or not the attorney fees or the charges are reasonable. So keep that in mind, that yes, they're charged back, but if you enter a stage of litigation, that changes, because it's in the hands of the judge who will make that final decision. So hopefully that answered those questions to a degree. And of course, if you have more specific questions or anything like that, feel free to reach out and we can look into it.
Yeah, I think the one thing I would just add to that is the caveat with subdivisions. With the homeowners associations, there are a fair amount of older declarations and other documents that are out there still that do not allow for the attorney's fees, that they don't specifically state that they're going to be charged back to the owner. So you would really have to look at your documents, because if it doesn't have that provision, it obviously impacts the type of action you're going to want to take a lot more, because you're going to be a little more, I think, a little more conservative when it's going to be the association that's going to have to pay those fees, because they can't be charged back to the owner. There was one other question. It looks like Kathy had to leave. She was asking about the example, my example 3 of why the second mortgage would be wiped out. It's because since there were 2 mortgages under the Michigan Condominium Act, the association's lien takes priority over the second mortgage, regardless of when it was recorded. So in that example, that since there was a second mortgage, it would get extinguished by the association's foreclosure sale. So I think that's all we had for questions. I'll just give it a second to see if anyone has anything else, or you can even feel free to unmute yourself if you want to ask a question instead of typing it in. Okay, if we don't have any more questions, then I hope everyone has a great evening. Thank you so much for joining us today. And if you do have any specific questions that you didn't want to ask on here, certainly send Matt or I an email, and then we will try and help you with the matter. I will see about sending the PowerPoint out to all of you that were registered. I'm not sure, but I will find out, Gail, and hopefully we can do that.